Supreme Court issues a notice on the rebel Shinde's plea, a notice that comes in the way of Uddhav Thackeray at this point. Uddhav Thackeray government now sees a notice from the Supreme Court. Let me quickly cut across to Nalini with more on that. Nalini, please define what this notice really says.
Well, Nabila, this is a notice that has been issued by the Supreme Court for all of the parties, particularly the Deputy Speaker of the Maharashtra Assembly, to respond to the petitions that have been filed by Eknath Shinde along with all of the other rebel MLAs. Two very important points coming across from the last update that we gave. Number one, the Supreme Court has asked the Deputy Speaker to file a comprehensive affidavit on two aspects. Number one, was there a letter that was received by him regarding a no confidence motion against him itself? And second, that if that no confidence motion was rejected, then on what basis, I beg your pardon, the Deputy Speaker rejected the no confidence motion against himself. So a detailed affidavit, a detailed comprehensive affidavit has been asked by the Supreme Court from the Deputy Speaker in Maharashtra on this particular aspect regarding the no confidence motion. The second most important update coming in from the Supreme Court is that Devdutt Kamath, who was the senior advocate appearing for the Maharashtra government, who had also spoken to the media earlier on behalf of the Shiv Sena, has specifically stated that there is no question of a no confidence motion against a speaker or a deputy speaker. A no confidence motion can only be moved against a CM or a government, not against the speaker. The constitution specifically mentions only removal of a speaker and not any question of a no confidence motion itself. So the Supreme Court has now issued notices to all of the parties, including the Deputy Speaker, the Maharashtra government, as well as the Shiv Sena faction led by Uddhav Thackeray, asking them to respond to the petitions that have been filed by the rebel MLAs. The next hearing, we are given to understand, is on 11th of July now, which is interestingly the day that the Supreme Court is reopening after the vacations conclude. So on the first day of reopening after the summer vacations, the Supreme Court is going to be taking up the Maharashtra political crisis for hearing. They have asked for the response to be filed by the Maharashtra Speaker as well as the Maharashtra Assembly within 5 days from today, and 3 days more after that will be given to the rebel MLAs to respond to the responses that have come in from the Maharashtra Speaker. This is the procedure that is followed. There's always a notice issued asking for the response on the other party on record. Even though the lawyer for the Deputy Speaker as well as the Maharashtra government have both made oral arguments before the Supreme Court today, so it's clear what their stand is going to be. They're challenging Supreme Court hearing this matter at all, saying that the proceedings before the Deputy Speaker have still not been concluded, but the Supreme Court wants all of these submissions on record, on paper, in a comprehensive manner, not in a short duration through oral arguments, which is why they've asked for a detailed response in this entire matter, not only from the Deputy Speaker but also from the Maharashtra government, specifically on the issue of the no confidence motion so far. It remains to be seen what response is filed by these people, but on the 11th of July is when the next hearing is going to be conducted before the Supreme Court. Some very important developments have undertaken before the top court today, which is likely to set the tone of this entire matter.
Nalini, hold on right there. I want to take this straight across to Paulami Saha as well, who's joining us for all the very latest from Guwahati on this story. Paulami, for our viewers who have just tuned in, do encapsulate all that is going on right now, because now the Supreme Court has issued a notice to the Uddhav government on pleas filed by the Shinde camp, and what's the sentiment you're picking amidst the Shinde camp at this point of time? Paulami, over to you.
Well, Jyoti, obviously we do know now that all of the respondents in this case have been asked to, in fact, submit an affidavit within 5 days' time as far as this entire matter is concerned, which includes, of course, the Speaker, the Maharashtra Government, Assembly Secretary, Mr. Ajay Chaudhary, Mr. Sunil Prabhu, and those others as well who have been made party to this petition, these two petitions by the Eknath Shinde camp.
Apologies about the interruption right there. Nalini's got some updates coming in from the Supreme Court. Take it away, Nalini.
Yes, Nabila, big breaking coming in from the Supreme Court. The Supreme Court has specifically asked the Deputy Speaker rather of the Maharashtra Assembly to ensure that the disqualification proceedings will not continue at least until the next date of hearing. Although another important rider is that the arguments are still underway and Rajiv Dhawan has said that he cannot give such an assurance without first speaking to the Deputy Speaker. But the Supreme Court made its intentions very clear. They've listed the hearing for July 11th and they're asking the Speaker to not conduct the disqualification proceedings at least until then, because the issue regarding the no confidence motion has to be decided first. No doubt if this is in the final order that is passed by the Supreme Court today, that the disqualification proceedings should not continue, then that will come as a massive relief to not only Eknath Shinde but all of the MLAs and the supporters who are with him in Guwahati right now, who are facing disqualification, to whom notices have already been issued to the Deputy Speaker. This is precisely what they were hoping for, some sort of interim relief. And if a stay is put on these disqualification proceedings, we are still waiting for the final order. The final order is not yet come in, but the Supreme Court made its intention very clear. They've said that the Deputy Speaker should not proceed with the disqualification proceedings at least until the next date of hearing, which is the 11th of July. So another roughly about 15 to 16 days more that the rebel MLAs will have to work out a strategy. They will not be disqualified until then, but we have to wait for the final order of the Supreme Court to see whether or not this makes it there, because the council who is representing the Deputy Speaker...
Let me get this right. You're talking to Chaudhary now. You're talking to Chaudhary now. Let me get this right. There is an interim relief that is come for the Shinde Sena camp on the back of this, because until 11th of July, none of those rebel MLAs will be disqualified, because the decision on the no confidence motion is supposed to be taken first. Have I got that right?
Absolutely, Chaudhary, you've got that absolutely right. But like I told you, there is a small rider because the arguments have not yet been completed and the final order has not been passed. But the Supreme Court's made it clear that they don't want these disqualification proceedings to continue until they decide on the no confidence motion and what the final decision in that is. The concern regarding the no confidence motion, Chaudhary, that the Supreme Court has is, can the Deputy Speaker even decide on a no confidence motion that has been passed against himself itself? Can he be a judge in his own case? Is the question that the Supreme Court's raising, which is why they have called for all the documents regarding this no confidence motion, which includes the letters that were sent by the rebel MLAs. And until a final decision is taken on that aspect, there is no question of conducting any further proceedings. But because Rajiv Dhawan's not given that assurance yet, it remains to be seen whether or not the Supreme Court's going to pass orders despite that, because sometimes the Supreme Court avoids putting things in orders and asks for an assurance from the council appearing before the court so that there is no prejudice against any one particular party. But in this case, since the council appearing for the Deputy Speaker still not giving the assurance that he is not going to put a stay on the disqualification proceedings that are already continuing,
Nalini, you are the best person to explain this. Nalini, you are the best person. To the layman, you know, this is too much of a legality. Can or cannot the Deputy Speaker decide against his own no confidence motion? What is, one, be the legal precedence in this regard, and what does the law say with this regard?
Well, Chaudhary, if we look at the larger perspective of things, one of the three principles of natural justice is that no man can be the judge in his own cause. So if this is an issue, anything to do with the Deputy Speaker, then the Deputy Speaker himself cannot be the one who is the deciding authority on that particular aspect. Now, because the subject of this no confidence motion is the Deputy Speaker, can he take an action? Can he take a decision as to whether or not he should be removed by himself? Is the question that the Supreme Court's asking. Abhishek Manu Singhvi stated this exact same principle of natural justice that I am stating before you before the Supreme Court, saying no man can be a judge in his own cause. That is why the Deputy Speaker himself cannot decide on the issue of the no confidence motion. Another very important point, though, that has come in, Chaudhary, is that Devda Kamath, who is representing the Maharashtra government, has put forth before the Supreme Court that there is no no provision in the constitution that even talks about a no confidence motion against the speaker. A no confidence motion can only be moved either against a chief minister or against a government. The constitution only talks about the removal of a speaker. So where are we getting this no confidence motion against a speaker from is a question that Devdutt Kamath has raised. So as to whether or not this no confidence motion is valid in law, is even legally valid in law, the Supreme Court will decide now, likely on the 11th of July, once they have all the documents before them.